Welcome to the deep dive. Usually when you are building a legal case, there's a fundamental expectation of tangible proof.
Right, absolutely.
Like if you get into a car crash, you show up to court with photos of the crumpled fender. If you're alleging a breach of contract, you point directly to the missing signature on the document.
You need something to show the jury.
Exactly. It's incredibly comforting to have the evidence right there in your hands. But what happens when the very product that injured you is the evidence, and it literally explodes into a million unrecoverable pieces?
It's a nightmare scenario.
Truly. Imagine the janitor sweeps up the shattered glass, throws it in the dumpster, and suddenly the physical proof you need to win your case is just gone forever. Okay, let's unpack this, because how do you prove a product was dangerously defective when the product itself literally explodes into a million unrecoverable pieces, destroying the very evidence you need for your case?
It really is the ultimate plaintiff's nightmare. And what's fascinating here is how the law steps in to bridge that seemingly impossible evidentiary gap.
I'm really curious how they pull that off.
Well, today we're dissecting the precise intersection of two major legal doctrines that usually live in entirely different worlds. On one hand, we have the circumstantial evidence rule of res ipsa loquitur.
Which is that Latin phrase, right?
Yeah, it essentially translates to the thing speaks for itself. And on the other hand, we have the incredibly rigid, demanding requirements of strict products liability.
Okay, so bringing those two together.
Right. We're going to map out exactly how courts synthesize these two concepts when the physical evidence is, currently sitting at the bottom of a municipal landfill.
I love this because it feels like a legal magic trick. I will be playing the role of the inquisitive proxy for our listener today, guiding us through the mechanics of product liability when the evidence is destroyed, while you act as the analyst.
Sounds like a plan.
But before we get into the heavy case law, we need to lay the groundwork. Why does the law even need strict liability to begin with?
That's a great question.
I mean, if a company's careless, we can just sue them for negligence, right? Or if they break a promise about their product, we sue for breach of warranty. Why create an entirely separate, seemingly harsher lane for strict liability?
It's a fair point.
It almost sounds like we're punishing manufacturers even when they did everything perfectly right.
That tension is exactly what makes this area of law so compelling. To understand why we have this doctrine, we really have to look at the black-letter law for strict liability, which is embodied in the restatement Torts 2nd, Section 402A.
Okay, what's the general rule there?
The general rule is this liability is imposed without any proof of negligence or privity of contract upon a manufacturer or seller for an injury caused by a dangerously defective product.
Let me stop you right there for a second, just to define a couple of things. When you say without privity of contract, you just mean the injured person doesn't need to be the one who directly bought the item from the manufacturer.
Precisely.
Like, if I buy a toaster and it hurts my roommate can still sue the company, even though they didn't sign a receipt with the manufacturer.
Exactly. Privity used to be a massive roadblock, but strict liability just sweeps it away.
And the other part, without any proof of negligence, that means a company could have, like, the most rigorous, state-of-the-art, multi-million-dollar safety testing facility in the world, and it just doesn't matter.
It does not matter.
If the product leaves the factory with a dangerous defect, they pay.
That is precisely what it means. The rule breaks down into three core elements that a plaintiff must prove. First, the product was in a defective condition, unreasonably dangerous for its intended use.
Okay, that's one.
Second, the defect existed when it left the defendant's control. And third, the defect was the proximate cause of the injury. If you hit those three, the manufacturer's level of care is completely irrelevant.
But if they weren't careless, what is the underlying logic for making them empty their wallets? It feels, a little counterintuitive to our basic ideas of fairness.
It does, until you look at the macro-level economics of it. The justification comes down to four major policy pillars, which were beautifully summarized in a landmark case called McCormick v. Hankscraft Co.
Let's hear them.
First, it's about promoting safety. Strict liability intensely discourages the marketing of defective products. Think about modern advertising companies spend billions inducing consumers to trust them.
Oh, for sure.
But consumers have absolutely no way to scientifically test a microwave or a car engine before they use it.
Right, I'm just trusting the commercial that says it won't explode.
Exactly. The second pillar is about loss distribution. The manufacturer is simply best equipped to absorb and distribute the financial loss of an injury as a cost of business.
Ah, so it operates almost like a micro tax on the product itself.
That's a good way to look at it.
Every time I buy a blender, a tiny fraction of a cent goes toward the inevitable reality that 1 out of 1 million blenders might hurt someone, and that person needs their medical bills paid.
That is a brilliant way to conceptualize it. The third pillar is maximizing consumer protection. Strict liability encourages reputable companies to settle valid claims quickly without dragging an injured person through a decade of agonizing litigation.
Just to prove a factory worker sneezed while assembling a part.
Exactly. And finally, the fourth pillar allows for direct action. An injured person can sue the party responsible for putting the product on the market without the agonizing delay of suing every single intermediate seller in the chain of distribution.
I see. Because otherwise I'd have to sue the retail store, who then sues the regional distributor, who then sues the wholesaler, who finally sues the manufacturer.
It would be a procedural nightmare.
I like to think of strict liability as a legal force field for consumers. It really doesn't matter how careful the manufacturer was. If a dangerous defect somehow slips through that massive corporate machinery and hurts you, the manufacturer is on the hook.
The force field protects you.
Right. It protects you from having to prove how the factory messed up, which you could never realistically do anyway.
That force field analogy is spot on. But as we're about to see, activating that force field is incredibly difficult when the product no longer exists to be examined.
Which brings us to our primary case study. Let's analyze Lee v. Crookston. First, what are the legally dispositive facts?
Okay, so the plaintiff is Helen Lee, a waitress working at a bustling steakhouse. Shortly before noon one day, a driver for the Crookston Coca-Cola bottling company delivered a 12-bottle case of 26-ounce Coca-Cola bottles.
Those are the big, heavy ones.
Right? Heavy, pressurized glass. The driver used a hand cart and stacked the case behind a counter near a waist-high cooler. The bottles sat there, completely undisturbed, until about 12:30 or 1. At that point, Helen Lee started transferring the bottles from the case into the cooler.
Just a totally normal, everyday task.
Completely routine. But while lowering the third bottle and without striking it against the cooler or anything else, it violently exploded with a loud bang. The neck and cap of the bottle remained in her hand, while glass fragments scattered 10 to 12 feet away. One fragment deeply punctured the median nerve in her right wrist.
Ouch. And I'm assuming in the chaos of a busy restaurant, nobody's thinking like a forensic investigator.
Precisely. Because she only needed a Band-Aid initially, the glass fragments were simply swept up and discarded. Later at trial, the defendant's expert, Dr. Fryer, claimed the missing bottle must have been struck by an external force. Because of this missing evidence, the trial court actually refused a strict liability instruction.
And what was the core legal issue?
The precise question was whether circumstantial evidence, which is sufficient to justify submitting a case to the jury on the negligence theory of res ipsa loquitur, is also sufficient to take the case to the jury on the theory of strict liability.
What rule of law did the court apply? Please state the full black-letter rule and break it down into its testable elements.
The court applied the strict liability rule from Restatement Section 402A. It has 3 elements. First, the product was in a defective condition unreasonably dangerous for its intended use. Second, such defect existed when the product left the defendant's control. Third, the defect was the proximate cause of the injury.
Okay, got it.
But importantly, they also integrated a sub-rule from a case called Holkstad. A plaintiff need not prove a specific defect if circumstantial evidence makes it more probable than not that the product was defective when it left the defendant's hands.
Thank you. Now for the court's elemental analysis. Let's walk through this step by step. How did the court apply the first element, defective condition?
So, doing a mini-RX here. The sub-issue was whether the exploding bottle was actually defective. The sub-rule dictates that a defect can be inferred circumstantially if abnormal alternative causes are eliminated.
Like a scientific process of elimination.
Exactly. In their application, the court analyzed Dr. Fryer's testimony on the 3 forces that break glass thermoshock, internal pressure, and external force.
So they just need to knock out the ones that aren't the manufacturer's fault.
Right. The evidence dispelled thermoshock because there were no temperature extremes, and it dispelled external force because of uncontroverted testimony that she didn't strike it.
Leaving only one option.
Yep. The only plausible explanation left was a defect unable to withstand normal internal pressure, likely from the bottler reusing old bottles. So the conclusion is that the circumstantial evidence satisfies the first element.
Understood. Now, what about the second element? Existed when leaving control.
Okay, sub-issue here. Did the defect exist before Helen Lee touched it? The subrule requires the plaintiff to eliminate the probability of improper handling by intermediate parties.
How did they apply that to the timeline?
The Coca-Cola driver had just delivered the case behind the counter. It sat undisturbed for less than an hour before she carefully lifted the bottles out.
So no phantom customers playing soccer with the crate.
Exactly, there was no third-party intermeddling. So the conclusion is that it's more probable than not the defect existed when the defendant relinquished control.
Understood. Now, what about the third element, proximate cause?
The sub-issue is whether the defect directly caused her damages. The sub-rule is that the injury must naturally flow from the defect.
And the application.
The internal defect caused the bottle to violently explode, and a resulting glass fragment directly severed the median nerve in her right wrist.
It's a direct, tragic chain of physics.
Exactly. So the conclusion is that proximate cause is clearly established.
And after analyzing all the elements, what was the court's final conclusion?
The Supreme Court of Minnesota reversed the lower court and granted a new trial. The court synthesized this by holding that it is manifestly inconsistent to allow a jury to infer negligence from circumstantial evidence using res ipsa, but deny them the chance to find strict liability from that exact same evidence.
That phrase, manifestly inconsistent, really feels like the emotional core of the ruling.
It really is. It just makes zero logical sense to say the evidence is strong enough to guess a company was actively careless, but not strong enough to deduce the product was simply broken.
Here's where it gets really interesting. Because let's test this rule with a highly visceral, gross hypothetical to see how far this circumstantial evidence bridge actually stretches.
Oh boy, okay.
Imagine you buy a heavily pressurized, sealed aluminum tin of imported, aggressively fermented fish from a local market, like surströmming.
I can already smell this hypothetical.
It's bad. You place it gently on your kitchen counter. Suddenly, the internal gases become so unstable that the tin detonates like a bomb. It sprays noxious, caustic fish guts everywhere, blinding you in one eye.
Good grief.
And the tin itself is completely shredded and thrown out by the hazmat cleanup crew before it can ever be analyzed. The manufacturer points to the destroyed tin and says, "You can't prove a specific defect. You must have hit it with a hammer."
If we connect this to the bigger picture, this shows exactly why the Levy-Crookston doctrine is so vital. Just like the shattered Coke bottle, the plaintiff doesn't need the destroyed tin to prove a specific structural flaw.
So I just run the exact same playbook of elimination.
Yes. As long as you can provide circumstantial evidence ruling out thermoshock like, you didn't boil the tin in external force, you didn't hit it with a hammer, the law allows the jury to infer strict liability for the dangerously defective fermented fish bomb.
It forces the burden back onto the manufacturer, rather than forcing you to perform impossible metallurgical analysis on a tin that no longer exists.
Precisely.
So what does this all mean for the listener who needs to apply this on an exam?
Well, you need an actionable diagnostic checklist. Here are the 5 steps. Step 1, identify the product liability claim. Is the plaintiff alleging negligence, breach of warranty, or strict liability in tort? Always assess all 3.
Okay, check all the boxes.
Step 2, outline the 3 elements of Section 402A, strict liability. Defect, existed at time of control, and proximate cause. Step 3, spot the evidentiary gap. Is the product destroyed or missing?
Right, point out why you can't just test the item.
Step 4, deploy the circumstantial evidence bridge. If the facts support res ipsa loquitur for negligence, immediately argue that this same circumstantial evidence supports an inference of a defect for strict liability.
That's the Lee case.
Exactly. And finally, step 5, rule out the alternatives. Methodically eliminate third-party mishandling, thermoshock, or external impacts, which covers the plaintiff's own contributory negligence, to successfully isolate the manufacturer's defect.
That is a phenomenal roadmap. It turns a missing bottle into your strongest argument.
It really does. But, this raises an important question, one to mull over. The Lee case works perfectly for a freshly delivered bottle.
Right, less than an hour pass.
But what happens to this circumstantial bridge when a product is 5 years old, has changed hands a dozen times, and then explodes? At what point does the circumstantial chain of custody stretch so far that the law simply refuses to let the thing speak for itself?
That is a brilliant puzzle for any legal mind. The timeline of control really is the fragile thread, holding that entire case together. You might not always have the tangible proof, but if you know how to wield the circumstances, the absence of evidence becomes the evidence itself. Keep questioning the world around you, and we'll catch you on the next deep dive.